ludicrous. If you use your common sense, you'll see that. Let's talk about timing. The defense told you that timing shows that the defendant could not be the murderer. That's simply not true. The timing actually shows that it was him. He was the murderer. He was the person on the trail. He was the person who killed Stephen and Wendy. The defendant left Shaw's at 2:28. That's not speculation. That's evidence. By 2:33, he was north of Loudon Road. You saw that video where he disappears into the distance. He waited at the crosswalk. He crossed. It was 2:33 when that video ended, as he went to that trail by Alton Woods, leading to the Marsh Loop Trail, leading to his home. He hadn't burned it yet. Detective Brown told you it took him 8 minutes to get from Loudon Road to the parking lot. The defendant had 8 minutes to get there. That would put him there at 2:41. It took Detective Brown 4 more minutes to get to the crime scene. Not to the campsite, but to the crime scene. That would put the defendant there at 2:45. That leaves a 15-minute window for him to kill Stephen and Wendy on that trail. Dr. Nutt didn't begin her hike until 2:48. Even if she spent a couple minutes getting ready, messing around, the defendant was long gone. It's not close. More than enough time for him to get through the parking lot and onto that trail where he killed Stephen and Wendy. The timing shows that the defendant is the one who was on that trail, and he's the one who killed Stephen and Wendy. Let's talk about some more timing. This is April 19th, 2022, at 9:52 in the morning. Stephen and Wendy haven't even been dead for 24 hours. They were killed the day before in the afternoon. The next morning, as their bodies are lying somewhere off the Marsh Loop Trail, the defendant went to Walmart. And what did he buy? A new tent, a new sleeping bag, and rubbing alcohol. His campsite was burned by April 20th, the next day. Is that a coincidence? It's not. The defendant bought those things and walked out of Walmart that day because he was about to burn his campsite, to destroy any evidence that could link him to those murders. He was going to destroy his home, the place where he had all of his worldly possessions, his refuge. He was going to burn his house to the ground because he had murdered Stephen and Wendy. He didn't do that because he was worried about a probation violation. He was worried that he'd get caught for murder. The timing tells you it was the defendant. Let's talk about some more timing. April 20th, Arthur Kelly talks to the Concord police. Arthur Kelly is sitting right here. That was him. On Wednesday, April 20th, the defendant lied to the police. They asked him about Stephen and Wendy, and he knew the jig was up. They were looking for the people he had killed. And so what does he do the next morning? He creates a new email address, not with a name, just end user. He creates a burner email, and he does it at 11:29 in the morning. The morning after the police asked him about Stephen and Wendy. One minute later, he bought a bus ticket out of town using his brand new email address, using the new identity he was creating for himself, Denton Kelly. He went to Portland. The defendant was using a different fake name than the one he'd given the night before because he knew he was guilty. He didn't want to be caught. And what else did he do that morning? The morning after the police asked him about Stephen and Wendy? he erased information from his computer. He conducted one of those fresh start procedures. He destroyed information on his computer, information like a browser history, information that could be used to identify him. And he did it so that the police would never find it. He gave himself a fresh start. A fresh start for Logan, for Arthur, for Denton. The timing proves it was him, and only him. No one else, just Logan Clegg. The defendant lived at that burn tent site. There is no dispute about that. The defense has admitted this. He was on his way home on April 18th when he killed Stephen and Wendy. That was when Dr. Nutt saw him on the trail. This is what happened to his home. This is what he did to his home, not because of a probation violation, because he had committed 2 murders. The police found 155 propane tanks there. And the defendant was right to try and conceal those, because that's how they found out who he was. The police were able to account for most of those being purchased by the defendant, over 100 at Walmart, more online via Amazon. There was a stove at the burnt tent site, just like the one he bought on Amazon. There was a pants label, charred and burned amidst all the wreckage and debris that he had left when he burned that place. 30-30, that was his size. And there were bullet casings too, lots of them. Bullet casings fired from his gun. No one else's gun, just his. There is no doubt that that tent site belonged to the defendant. And there is no doubt that those casings came from his gun. He lived there when he got to Concord in November, and he was still living there in April. He didn't leave until after the murders, after he had killed Stephen and Wendy, after he bought that new tent on April 19th, because he knew he was going to burn it to the ground, the one he was living in. Now, the defense told you that the defendant was scared, that he was scared about his probation issue from Utah, and that's why he did all these things. That's why the morning after the murders, or after he's discovered, I should say, he creates a new identity and gets the hell out of town. And the morning after the murders, he goes and he buys a new tent, a new sleeping bag, and burns his house down. Ask yourselves, does that make any sense? Does it make one bit of sense? That a person would destroy their home because of a probation violation? It doesn't. The defendant wasn't worried about his probation issue when he used his real name at McDonald's the whole winter. There's that email address. He wasn't worried about his probation when he bought magazines for his gun online. He had them shipped to Logan Clegg in Concord. 2 magazines that could hold 17 rounds, higher capacity than what he could buy in Vermont. The defendant wasn't worried about his probation when he bought those things. And he didn't care about his probation when he burned his tent. What he cared about was getting caught for the murders he had committed, the murders of Stephen and Wendy. The defendant didn't burn his home because Officer Craig visited him on April 15th. The defendant wasn't there. The officer told you no one was there. The defendant wasn't there. So that's not a reason for him to burn his tent. The only reason was that he had killed Stephen and Wendy. The defendant told you that science, or the defense told you that science shows Logan could not be the killer. Let's talk about science. The science tells us that it was Wendy's blood on that trail and on that pill bottle. Science tells us that she was killed on the trail and dragged off of it by the defendant. Science tells us that there was baking soda sprinkled on top of that mound of sticks and leaves. You heard about Amber Smith. She's a DNA analyst. She tested a lot of samples. And what were the results when she tested those samples? Inconclusive, 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 inconclusive. Inconclusive after inconclusive. It doesn't tell us that Logan is guilty, but it doesn't make him innocent either. The 3 samples from Stephen's sock, his boot, and his belt had some more statistics attached to them, but the result was the same. Logan Clegg could not be excluded from those samples. Amber Smith could not say that he was not a contributor to the DNA in those samples. So what does that tell us? Nothing. It doesn't make him innocent. The samples were degraded. They had minimal DNA in them. That's because after the defendant killed them and buried them, they sat in the rain for 2 days in the elements. Of course, there wasn't enough DNA to do testing. The medical examiner told you that their clothes were so waterlogged they weighed almost 10 pounds. We don't know if the defendant had his DNA in those samples, but Amber Smith didn't tell you that that wasn't him. We want to talk about science. We talk about ballistics. Jill Terrio tested those casings and tested those bullets. Those casings came from the defendant's gun. The casing from Vermont, the casing from the burnt tent site, all 18 of them, and the casings from the trail. This is undisputed. They came from his gun, the Glock that was in his backpack. Now, Jill Terrio formed the opinion that those bullets and those casings probably came from a Glock 9mm pistol. She did that months before the police knew about Logan Clegg. Months before they found his gun in his backpack. That's science. That's just what the evidence told her. And why did she consider them together? Does it make any sense to consider bullets and casings that are found at the same crime scene together? Yes, it does. Let's talk about confirmation bias. Jill Terrio forming an opinion that the gun that fired those bullets and those casings was probably a Glock and not any of those other ones. That's not confirmation bias. That's science. She didn't know about the defendant's Glock. She didn't know about Logan Clegg and then have a bias towards the evidence that she saw to make it look like it was him. No, the evidence came first. He came later. The Concord police didn't have confirmation bias. They didn't misinterpret any evidence. They didn't have guilt-colored glasses on when they did this investigation. The police didn't find the defendant because they were biased. They found him because that's where the evidence led them. They had investigated the deaths of Stephen and Wendy for 5 months before they learned his name, before they found him. The evidence led them there, not any bias. The police went through Walmart video and receipts for days. They sifted through propane tanks and burnt labels and charred scissors and all the other garbage that was up there. They reviewed records for prepaid debit cards and business records for online transactions. They did search warrants. All that evidence led them to him, the killer. Just him, no one else. When the police found the defendant, he had thousands of dollars in cash with him. He had new clothes at his tent site. He had that fake Romanian ID with his picture and a fake name on it, and a one-way ticket to Germany. He was planning to run away and never come back. He wasn't going on vacation. He was escaping. The defendant's actions are evidence of his consciousness of guilt. They are evidence that he knew he was guilty. He was guilty and he knew it, and he wanted to cover it up. Innocent people don't burn their homes, the place that they live for months and months through a New Hampshire winter, when they don't have anywhere else to go. He didn't have anywhere else to go. He didn't burn his home because of a probation violation. He didn't destroy his only source of heat and shelter. He did that because he was guilty. Innocent people don't conceal the bodies of the people that they have killed under leaves and sticks and twigs and baking soda. Innocent people don't remove shell casings from a crime scene like the defendant did. And innocent people don't give police a fake name when they ask about missing persons. The police asked him about the people he killed, so he gave a fake name. People who are innocent don't use fake identities the day after they're discovered. They don't buy bus tickets using those fake identities and then erase information from the computer afterwards. These are not things that innocent people do. Innocent people don't have clearly fake Romanian ID cards shipped from England in their backpacks. The defendant did. Innocent people don't buy one-way tickets to Germany and refuse to tell their coworkers where they're going. Erica Collins asked him, "Where are you going?" "I can't tell you." It's not something an innocent person does. We're running out of room on the slide here. Innocent people don't have a gun and $7,000 in cash in their backpacks. All of these things and more show that the defendant was guilty. They are consciousness of guilt. They are proof of it. He knew he was guilty, and so that's why he did these things. He tried to run away and hide from the crimes he had committed. He didn't do these things because of a probation violation. He did them because he murdered Stephen and Wendy. The defendant didn't leave Concord because of a probation violation. He didn't burn his tent site because of a probation violation. He didn't do any of these things because of that. There's more. Wouldn't fit on the first slide. Innocent people don't search Concord, New Hampshire news when they have no connection to Concord. The defendant searched Concord, New Hampshire news on July 31st of 2022. He did it again in October. This information was not on his laptop. It was gone. Police only had about 3 hours worth of browser history. This they had to go directly to Google to get, to find it, because it was gone. The morning of his arrest, the defendant Googled Concord, New Hampshire news as he was preparing to leave the country, to leave forever. He was looking over his shoulder. He was looking in the rear view to see if he could see lights. He wanted to make sure he had covered his tracks. He was checking on the investigation. He wanted to make sure that no one had caught him and no one would find out that he had murdered Stephen and Wendy. He didn't Google news for Burlington. He didn't Google Portland, Maine, where he went. He didn't Google Utah, where his probation violation was. Just Concord, the place where he had no friends, no relatives, no family, and no connections. The only connection that he had to Concord was the murders that he had committed. Those were the defendant's actions, and they show that he knew he was guilty. Let's talk about his words. When the defendant spoke to Detective Brown, he lied. He lied and lied and lied again. He lied at the beginning of the interview, he lied in the middle, and he lied at the end. All lies. He didn't tell those lies because of a probation violation. Those words are evidence of his guilt. You can hear them. They show that he was guilty and he knew it. The defendant lied about when he left Concord. He said he left in February or maybe March when there was snow on the ground. But you know that's not true. That was a lie. He lied about when he left Concord because he knew that he had murdered Stephen and Wendy in April. He didn't want the police to know he was here. You know he was in Concord because he was on video and on camera, buying things, buying magazines, shipping them to Concord. You've seen him. He was here. He was Arthur Kelly on April 20th in Concord. The defendant lied about where he shopped. He knew the police were looking for a person with a tent and a lot of propane tanks. He said he never had a tent. He said he never bought propane tanks. And he said he only went to Walmart a couple of times. He shopped at Shaw's instead. These were all lies. And you've seen the evidence. You know that they're lies. He didn't lie about where he shopped because of a probation violation. He lied about where he lived. He said he had never heard of the broken ground trails, wasn't familiar with them. He said he lived on the south side of Loudon Road by Shaw's and Home Depot. We know that's not true. He lied because he knew where he had killed Stephen and Wendy. It was on the Marsh Loop Trail, and he was living just north of there. But he lied about it. Said he had never been there. He was covering his tracks. He lied about contact with police. He lied because he knew the police had spoken to Arthur Kelly looking for Stephen and Wendy, the people he killed. He didn't want anyone to find out that he was Arthur Kelly. Detective Lemoyne spoke to Arthur Kelly, and he told you that's him right there. The defendant said, I don't know who Arthur Kelly is. Never heard that name. Even after Detective Brown told him an email address linked to Arthur Kelly is on your McDonald's application, he lied. He said, I don't know what you're talking about. It was a long time ago. He lied because he knew he was guilty. The defendant lied about having a gun. The detective asked him twice. He lied both times. He lied because he knew Stephen and Wendy had been shot and killed when he pulled the trigger. The defendant told all these lies because he was worried about being caught for the murders, not a probation violation. The reason he might have been afraid that something bad would happen with his probation was that he didn't want to be caught, and he didn't want to be found and arrested for leaving Utah. That was the reason. Well, when he spoke to Detective Brown, the defendant had been found and he had been arrested. Nothing he said could change that. He couldn't get arrested again. He knew where he was. He knew what had happened. The jig was up. The Detective Brown told the defendant, I don't care about Utah. I don't care. I'm only here for what happened in Concord. The defendant knew what they were talking about. He didn't lie about things that would violate his probation. He told Detective Brown he went to Germany, went on vacation, took a trip. That would violate his probation. He didn't lie about that. He did lie about where he shopped in Concord. Would that violate his probation? No. He lied about knowing the broken ground trails, not a probation violation. The defendant lied because he didn't want to be caught. He didn't want to be caught for murdering Stephen and Wendy. The state has proven to you over the past 3 weeks now that the defendant, and the defendant only, killed Stephen and Wendy. We have proven this to you beyond a reasonable doubt. We have proven to you how he did it, when he did it, where he did it. What we don't know is why. We just don't know. The fact that we don't know why Logan Clegg pulled that trigger and killed Stephen and Wendy does not change the fact that he is guilty. He murdered them. It does not mean that there is any reasonable doubt that he's the one who did it. There wasn't a soul on this planet who would have had a motive to kill Stephen and Wendy. They were beloved by their friends and family. They traveled the world doing good deeds. They had no enemies. Their killing was senseless. No one had a reason to kill them. But their killing was still murder. No matter what the motive of their killer was, it's murder. And the killer is sitting right there. The defendant is the person who murdered them. The judge is going to tell you that motive is not, well, he's going to tell you what the elements of the crimes the defendant is charged are. Motive will not be one of them. The evidence shows, beyond a reasonable doubt, that Logan Clegg murdered Stephen and Wendy. He is guilty. It doesn't matter why he did it. The judge will give you some other instructions to guide you in your deliberations. He is going to tell you that the elements, what the elements of each charge against the defendant are. And one of those instructions will involve circumstantial evidence. The judge will tell you, and listen to his words, not mine, that to establish doubt, beyond a reasonable doubt, to establish guilt, when the evidence is solely circumstantial, all other rational conclusions besides innocent must be established. In this case, there is no rational conclusion from the evidence, direct or circumstantial, besides guilt. Evidence is evidence, direct or circumstantial. Is it rational that there was another person wearing the same clothes, carrying the same bags, wearing the same backpack, traveling the same path at the same time as Logan Clegg, carrying a shopping bag with a round thing in it, with a Glock 9mm pistol with polygonal rifling and a holster? No, that's not rational. Is it rational to think that someone else, not the defendant, somehow found shell casings from his gun and planted them at the scene of a crime weeks or days after that crime was committed, and just so happened to plant them in the same place that Stephen or Wendy were killed? No, that is not a rational conclusion. Is it rational that the defendant would burn his home, everything he owned, all of his worldly possessions, just because he was worried about a probation violation? Because he was scared? No. And he just so happened to do that the day after Stephen and Wendy were killed, with bullets and casings came from his gun? No. Is it rational that the defendant would lie about going to Walmart and which side of Loudon Road he lived on because of a probation violation? No. These conclusions are not rational, they're not reasonable, they're not even remotely plausible. They are ludicrous. You don't have to believe them. You can reject them, and you should. The judge will tell you that you should consider each item of circumstantial evidence not in isolation, but in context of all the other evidence. And he's right. When you do that, instead of looking at little things in isolation, you will know that the only rational conclusion that you can reach based on this evidence is that he is guilty. The defendant is charged with being a felon in possession of a firearm. They have admitted that he is guilty. He is guilty. He is guilty of possessing that firearm that he bought in Vermont using a fake name. It's the same firearm he used to kill Stephen and Wendy. The defendant is charged with falsifying physical evidence for executing a fresh start procedure on his laptop on April 21st of 2022. The judge will tell you that to find him guilty, the state must prove that the defendant believed there was an investigation pending or about to be instituted, and that with a purpose to take evidence away from that investigation so they wouldn't be found, he altered, destroyed, or removed some information from that computer. That's what he did. The timing tells you that's what he did. He erased information from his computer so he could not be identified as the killer. He is guilty. The defendant is charged with falsifying physical evidence for burning his campsite. He knew the police would come looking. He knew there would be an investigation, and he destroyed evidence so that the police would never find it. with a purpose that that evidence would not be found. He is guilty. The defendant is charged with 2 counts of falsifying physical evidence for concealing the bodies of Stephen and Wendy, his victims. The defendant knew after he murdered them there would be an investigation. He knew the police would come looking, so he moved and concealed their bodies. He did it with a purpose that they not be found. He's guilty. And finally, the defendant is charged with second-degree murder. He's charged with 2 types. The judge will tell you to consider each independently. The defendant is charged with knowing second-degree murder for killing Stephen and Wendy, 1 count each. In order to find him guilty, the state must prove to you beyond a reasonable doubt that the defendant caused their deaths and that he did so knowingly. When the defendant pulled the trigger of his gun and fired those 6 shots at Stephen and Wendy, he knew what he was doing. He caused their deaths. He was aware of the nature of his conduct. When he shot those bullets at Stephen and Wendy, he knew he would cause their deaths. Find him guilty. The defendant is charged with reckless second-degree murder for killing Stephen and Wendy. The judge will instruct you that to find him guilty of that charge, the state must prove to you beyond a reasonable doubt that the defendant caused their deaths, which we know he did, and that he did so with reckless indifference, manifesting an extreme indifference to the value of human life. He will tell you what those words mean, and you will know that he is guilty. This has been a long trial. You've been here for 3 weeks. There has been a lot of evidence put before you. Business records, video, photos, cell phone experts, chemists, DNA, ballistics. The trial belongs to you now. You get to decide what the truth is. When you consider all of the evidence, there can be no doubt whatsoever what the truth is. The truth is that Logan Clegg killed Stephen and Wendy. He murdered them. After he murdered them, he tried to cover his tracks. He burned his home. He fled using fake names. He erased information from his computer. He concealed the bodies. He concealed his crimes and then he fled because he knew he was guilty. And he kept running and hiding until he got caught. And when he was caught, he lied. Lied and lied again, no matter how ridiculous those lies were, because he knew he was guilty. The defendant has nowhere left to run, and he cannot hide. He cannot hide from the evidence, and he cannot hide from the truth. He cannot hide from the verdict that you will deliver. In light of all of the evidence, find him guilty of murdering Stephen and Wendy. Thank you.
Thank you, Attorney Spicer. So what I'm going to do is take another break, take another short 5 or 10 minute break, then I'll have you come back and read the instructions. I'll tell you right now what I'm going to do is we're going to read the instructions and then I will select who the alternates are at the end of that process. I do it randomly. I have a little jar with balls with numbers on them. That's how I'll do that. And then what I'm going to say is given the hour after I read the instructions, we'll adjourn for the night, and I'll have you come back at 9 o'clock tomorrow to begin your deliberations. So even though I said we're close to letting you talk about it, I need to give you the instructions, and given the hour, it's going to take us a few minutes to get copies of the instructions ready for you and to gather all the exhibits, and I'd rather do that when we can bring you in for a fresh start. But we'll take a short recess now, probably about 5 or 10 minutes, and then I'll have you come back in so I can read the instructions and you'll be able to start your deliberations tomorrow. Take a short break.
All rise.
Everyone can have a seat. And you're all free to, if you want to take a short break.
Where's the recess? If you'd like to get up, take a break.
tomorrow morning at 9 a.m. to begin your deliberations. But at that point, you will decide a verdict in this case. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you will have to understand the definition of the crimes with which the defendant is charged, what to consider in deciding whether to believe a particular witness, and how convinced one way or the other you should be before you reach a verdict. These instructions will explain the laws, these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all the instructions I'm about to give you. And don't worry, I will have copies of them sent in so you have them with you during your deliberations tomorrow. You must follow the law as I explain it, regardless of any opinion you may have as to what the law ought to be. It is up to you to determine the facts in this case. You must decide this case solely on the evidence presented at trial and the law as I explain it. You should reach a fair and just verdict without prejudice, without fear, and without sympathy. The fact the defendant has been arrested and charged is not evidence of guilt. The indictment is simply a way of giving the defendant notice of the charge against him. The indictment is a formal way of accusing the defendant of the crime charged in order to bring him to trial. In your deliberations, you must not consider the defendant's arrest, the charge, or the fact the defendant has been brought to trial as evidence of his guilt. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence for the judge. You should base your verdict only on the evidence of the law without considering the possible punishment. The defendant has an absolute right not to take the stand and testify. The fact the defendant did not testify in this case may not be considered by you in any way in deciding this case. The burden is on the state to prove the defendant's guilt beyond a reasonable doubt. The defendant has no obligation to present any evidence or to prove that he is innocent. You have heard the lawyers discuss the facts and the law and their arguments to you. These arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers state the law differently from the law as I explained to you, then you must follow my instructions and ignore the statements of the lawyers. If the lawyers state the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. In this case, I permitted the jurors to take notes during witness testimony. Please keep in mind that you should rely not only on your notes, but on your eyes, your ears, and your common sense. Do not use your notes as authority to persuade other jurors. Your notes are not official transcripts. They are personal memory aids, just like the notes of counsel and the judge. While you may find that your notes are valuable because your memory might otherwise fail you, you may yourself have made a mistake when taking notes. Therefore, you are not to use your notes or the notes of your fellow jurors as authority in persuading other jurors of what the evidence was during the trial. During your deliberations, you should consider only the evidence presented at trial. The evidence in this case consists of the testimony under oath of the witnesses, the exhibits, the view, and the stipulations. You may not guess or speculate about evidence. You may only consider what has been introduced into evidence and the reasonable inferences that can be drawn from the evidence. By reasonable inferences, I mean conclusions which reason and common sense lead you to draw from the facts that are proven to your satisfaction. During the trial, the lawyers made objections. The lawyers are supposed to object when they believe certain evidence is not admissible. If I sustain an objection or excluded any evidence, you must not guess as to what the answer or evidence would have been. If I order that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. Likewise, if I overruled an objection and allowed a witness to answer a question, you are not to give such evidence any special importance as a result of my ruling. When I rule on an objection, I'm merely applying the law as is my duty. If you believe that I suggested or expressed an opinion as to the facts in my rulings, you should ignore such opinion. The court in this case, as in all cases, is completely neutral and impartial. It is up to you alone to decide the facts in this case. There are two types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. Let me give you an example that is all too familiar to us here in New Hampshire, and I know has been referenced by counsel in different ways. Let's suppose you go outside and see snow falling from the sky. That is direct evidence that it is snowing. On the other hand, let's say you go to sleep at night, and before you go to sleep, the ground outside of your home is completely bare. You wake up the next morning, and there's a foot of snow on the ground. that is circumstantial evidence that it has snowed overnight. That is all there is to circumstantial evidence. On the basis of reason and common sense, you infer from an established fact the existence or non-existence of another fact. You should consider both types of evidence. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it be direct or circumstantial. However, there is a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of the charged offense, then in order to convict, you must find the totality of the evidence excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. Therefore, if there's a conflict between witnesses who offer direct evidence concerning certain facts, you should resolve the conflict. For example, suppose there are two eyewitnesses to a crime, and one testifies the defendant committed the crime, and the other testifies the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, should resolve the conflict and must decide whether, based upon all of the evidence, the state has proven the defendant's guilt beyond reasonable doubt. In summary, you should consider all the evidence in the case and decide whether the state has proven the defendant guilty beyond reasonable doubt. In reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or quantity of evidence that is important. What is important is the quality of the evidence. In deciding whether the state has proven a charge against the defendant beyond a reasonable doubt, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean you have to accept the testimony as true. In deciding which witnesses to believe, you should use your common sense and judgment. I suggest you consider a number of factors: whether the witness appeared to be candid, whether the witness appeared worthy of belief, the appearance and demeanor of the witness, whether the witness had an interest in the outcome of the case, whether the witness had any reason for not telling the truth, whether what the witness said seemed reasonable or probable, whether what the witness said seemed unreasonable or inconsistent with other evidence in the case, or with prior statements by the witness, and whether the witness had any friendship or animosity towards other people in the case. In deciding which witnesses to believe and how much of their testimony to believe, you should consider both the direct and cross-examinations of the witnesses, regardless of who called the witness. You should consider these factors in deciding the credibility of all witnesses, whether or not they happen to be ordinary citizens, police officers, or experts. You can accept all of what a witness has said, you can reject all of what a witness has said, or you can accept some of it and reject some of it. In short, you should consider the testimony of each witness and give it the weight you think it deserves. Now, as I said, in deciding whether to believe a witness, you may consider whether the witness made statements before trial which are not consistent with the witness's testimony at trial. Thus, if the witness made a prior inconsistent statement, you may use that statement in deciding whether to believe the witness's trial testimony. Keep in mind that you may use a prior statement only in assessing the witness's credibility. You may not use a prior statement as proof that the facts in that prior statement are true. There are, however, two exceptions to this general rule that prior statements may only be used in assessing witness credibility. If the statement made before trial was made by the defendant or by a witness under oath, then you may use that prior statement as proof that the facts in the statement are true. You have heard the opinion testimony of expert witnesses. An expert is someone who has acquired some specialized knowledge, such as scientific or technical knowledge from experience, training, or education, that qualifies the expert to give an opinion as to matters that are not common knowledge. The opinion of the expert may assist you in deciding the evidence or in deciding a fact and issue. You are not bound by the opinion of an expert. You are free to ignore the expert's opinion if you find the reasons given in support of the opinion are not sound, or if you find that other evidence outweighs the opinion. A stipulation is evidence. It is an agreement between the prosecution and defense that certain facts are true. You must accept these facts as true. You have heard evidence the bullets in the ammunition boxes seized in Vermont were examined and found to be total metal jacket. The boxes that contained the bullets were labeled, quote, full metal jacket, end quote. The parties agree that this difference was a result of mislabeling by the manufacturer and not the result of changes made after purchase. The parties further agree that Logan Clegg applied for a job at Price Chopper on May 18th of 2022 and provided the email address dentkelly0707@gmail.com. A language other than English was used during the testimony of a witness during trial. The interpreter's responsibility is to translate from English to the other language and from the other language to English as accurately as possible for effective communication. The evidence you are to consider is only that provided through official court interpreters. Treat the interpretation of a witness's testimony as if the witness had spoken English and no interpreter was present. Do not allow the fact that testimony was given in a language other than English to affect your view of that witness's credibility. If any of you understand the non-English language used, then you must disregard completely what the witness said in his or her own language. Consider only as evidence what was provided to you by the interpreter in English. If you think the interpreter made a mistake, you must ignore it completely and make your deliberations on the basis of the official English interpretation. Under our constitutions, all defendants in criminal cases are presumed to be innocent unless proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent person, and you must consider him to be an innocent person unless until the state convinces you, beyond a reasonable doubt, that he is guilty of every element of the alleged offense. If, after all the evidence and arguments, you have a reasonable doubt as to the defendant having committed any one or more elements of the offense, then you must find him not guilty. A reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason, as remains after consideration of all the evidence the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proved all the elements of the crime charged beyond a reasonable doubt, you should find the defendant guilty. The laws of New Hampshire set forth certain crimes. Each crime has a precise definition with at least two parts or elements, a mental state and an act. In deciding whether a person is guilty of a crime, you must determine both what the person's actions were and what his mental state was. For a person to be guilty of a crime, he must have the requisite mental state and he must have physically acted to do something that is criminal. The word act refers to a physical deed. The words mental state refer to what a person mentally believes his physical acts will accomplish. The matter of determining a person's mental state is something you will have to decide. There is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and all the circumstances based on the evidence presented in the case in deciding whether the state has proven that the defendant had the requisite mental state and acted to do something that is criminal. If I define the mental state that applies to a specific charge as I read them to you, that same definition applies to all the other charges with that same mental state. I will not repeat the mental state definition for the other charges with the same mental state. In this case, the defendant is charged with 4 counts of second-degree murder, 4 counts of falsifying physical evidence, and 1 count of being a felon in possession of a firearm. You must consider each of these charges separately and independently from each other. The first count charges the crime of second-degree murder. The definition of this crime has 2 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of Djeswende Reid by shooting her with a gun, and 2, the defendant acted knowingly. Certain words must be further defined. Knowingly means the state must prove the defendant was aware of the nature of his conduct or the circumstances under which he acted. The state does not have to prove the defendant specifically intended or desired a particular result. What the state must prove is that the defendant was aware that his conduct would cause a certain result. The second count charges the crime of second-degree murder. The definition of this crime has 2 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of Stephen Reid by shooting him with a gun, and 2, the defendant acted knowingly. The third count charges the crime of second-degree murder. The definition of this crime has 2 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of Djeswende Reid by shooting her with a gun, And 2, the defendant acted recklessly under circumstances manifesting an extreme indifference to the value of human life. Certain words need to be further defined. A person acts recklessly with regard to a material element of an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that the material element exists or will result from his conduct. The risk must be of such a nature and degree that, considering the circumstances known to him, its disregard constitutes a gross deviation from the conduct a law-abiding person would observe in the situation. For a killing to be second-degree murder, the defendant must not simply act recklessly, but rather must act recklessly under circumstances showing an extreme indifference to the value of human life. This means something more than merely being aware of and consciously disregarding a substantial and unjustifiable risk. The risk involved and the disregard must be so blatant as to manifest extreme indifference to the value of human life. The third count charges the crime of second-degree murder. The fourth count charges the crime of second-degree murder. The definition of this crime has 2 parts or elements. The state must prove each element beyond reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of Stephen Reid by shooting him with a gun, and 2, the defendant acted recklessly under circumstances manifesting an extreme indifference to the value of human life. The fifth count charges the crime of falsifying physical evidence. The definition of this crime of falsifying physical evidence has 3 parts or elements. The state must prove each beyond a reasonable doubt. Thus, the state must prove 1, the defendant believed that an official proceeding or investigation was pending or about to be instituted. 2, the defendant moved and concealed the body of Stephen Reid. 3, the defendant's purpose in committing that act was to impair the verity or availability of the physical evidence in the proceeding or investigation. Certain words need to be further defined. A person acts purposely when his or her conscious object is the cause, result, or engage in the conduct that comprises the element. The key words here are conscious object. To have a conscious object means to have a specific intent. It means that the defendant desired to engage in certain conduct. It is not enough for the state to prove the defendant knew or was aware of what he was doing. To prove the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to do a particular act. The sixth count charges the crime of falsifying physical evidence. The definition of the crime of falsifying physical evidence has 3 parts or elements. The state must prove each beyond a reasonable doubt. Thus, the state must prove 1, the defendant believed an official proceeding or investigation was pending or about to be instituted. 2, the defendant moved and concealed the body of Djeswende Reid. 3, the defendant's purpose in committing that act was to impair the verity or availability of the physical evidence in the proceeding or investigation. The 7th count also charges the crime of falsifying physical evidence. The definition of the crime of falsifying evidence for this count has 3 parts or elements. The state must prove each beyond a reasonable doubt. Thus, the state must prove 1, the defendant believed an official proceeding or investigation was pending or about to be instituted. 2, the defendant burned his tent and campsite after the deaths of Stephen and Djeswende Reid. 3, the defendant's purpose in committing that act was to impair the verity or availability of the physical evidence in the proceeding or investigation. The 8th count charges the crime of falsifying physical evidence. The definition of the crime, as set out here, has 3 parts or elements. The state must prove each beyond a reasonable doubt. Thus, the state must prove 1, the defendant believed an official proceeding or investigation was pending or about to be instituted. 2, the defendant destroyed or removed information on his laptop computer. 3, the defendant's purpose in committing that act was to impair the verity or availability of the physical evidence in the proceeding or investigation. The official investigation referred to in this charge is the investigation to the deaths of Stephen and Djeswende Reid. The information destroyed or removed from the defendant's laptop on April 21st of 2022 that was relevant to the investigation was operating usage records, network event logs, browsing history, and program data from the defendant's laptop that would have contained evidence of the defendant's use of the laptop on April 21st of 2022 to create a new email address and book a bus ticket leaving Concord the following day, as well as evidence linking the computer to the defendant. The 9th count alleges the crime of being a felon in possession of a deadly weapon. The definition of this crime has 2 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant knowingly had in his possession or under his control a firearm, a deadly weapon, and 2, the defendant had previously been convicted of a felony against the person or property of another. Certain words need to be further defined. A deadly weapon means any firearm, knife, or other substance or thing which in the manner it is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. Ladies and gentlemen, this case is important to both of the parties, the state and the defendant. In your deliberations, you should follow these instructions which the court has given you, which I have promised I will have copies for you tomorrow. You should not decide this case out of bias or sympathy, but with honesty and understanding. You should make a conscientious effort to determine what a fair and just result is in this case, because that is your highest duty as officers of this court. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each and every juror agree with the verdict. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or merely for the purpose of returning a verdict. When you have considered and weighed all of the evidence, you must make one of the following findings with respect to each of the charges before you. If you have a reasonable doubt as to whether the state has proved any one or more elements of the offense charged beyond a reasonable doubt, you must find the defendant not guilty. On the other hand, if you find the state has proven all of the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. Because only 12 jurors will be deliberating, I will now select the alternates at random. This is always a tough time for me, especially after a trial of some duration, because you've all been equally great about showing up on time here. Jury number 3,